and contempt case. Today itself I filed Okalatnama for respondent number 12.
Okay.
So, my lord, this matter will also come on some time we are given to file affidavit, my lord.
Okay.
On 28th.
Learned Counsel, Mr. S.K. Mehdi has submitted that he has entered appearance for the respondent number 12 and has filed his Wakalatnama only today. Stop. Accordingly, he prays for some time to file his affidavit in opposition. Stop. Learned Counsel for the petition. Who's for the petitioner?
My lord, petitioner, I've informed him, my lord.
Okay. The Learned Counsel for the petitioner has been informed. Stop. Accordingly, list the matter after 3 weeks in order to enable the respondents to file the affidavit in opposition. Okay, 3 weeks.
Yes. My lord, on 28th, my lord. Same day.
Same day?
Yes.
Okay, list on 28th then. 28th.
May I please, Your Worship?
Yes.
If I may be allowed to mention from part 2, item 6. In this matter, the respondents were directed to produce the case diaries. This is a writ petition under Article 226, praying for a direction that a CBI inquiry should be conducted into the death of the brother of the petitioner. And police case was registered and investigation ended in a final report. So we had challenged the final report by filing a protest petition.
Okay.
And the Honorable Court had directed for further investigation. So, but we have challenged the orders to the extent that it should be conducted by the CBI. So,
Okay.
and the case diaries were required to be produced. So, if this matter may be fixed on the 9th, coming Tuesday.
Okay. Learned Counsel for the petitioner, Mr. A.R. Malhotra. Who are you appearing for? In this? Oh, you're not here. Okay.
He's on leg, Your Worship.
Okay.
Mr. Samuel Valnoshiada.
Okay. It is submitted that on the last occasion, the court had directed the respondents to produce the case diary. Case diary. Stop. Accordingly, this is the matter on 9th.
Yes, Tuesday, coming
Okay,
Tuesday.
on 9th September. Yes.
My lord, this is not item 19, my lord, it is 6, my lord. Because of my lord, year, my lord, 2025, the hour is 2023, my lord.
Item 6 in part 1.
Yes, my lord. I've mentioned item 19. It should not be 19.
Okay.
My friend is there.
So, not item 19, item 6.
6.
Item 6. Okay.
For motion, item 3.
Your Lordship,
Yes.
on behalf of my senior advocate, I would like to seek indulgence in mentioning part 2, item number 9.
Part 2.
Yes. With the consent of other party, we would like to solve this matter on coming Thursday.
Day after?
Yes, this coming Thursday, yes.
No, let it be next week. Thursday, I don't think this court can take up any hearing matters. Next week?
Yeah. Yes.
9. On the prayer of the Learned Counsel for the petitioner or appellant. You are for the appellant?
Yes.
Appellant or respondent?
Appellant.
Appellant for the appellant, Mr. Such and such. And with the consent of the, you have taken the consent of the other side?
Yes.
With the consent of the other side, list the matter next week for hearing. Okay.
That's a blank.
Item 3 for motion.
Lordship,
Yes.
the petitioner has been placed in a merit-based appointment and to hold the post of a sectional assistant SA, level 4 in the pay matrix on regular basis under irrigation and water resources. However, after this appointment, the appointment letter has been cancelled, Lordship, so we are seeking this court's intervention. We are also challenging the cancellation order, Lordship, which is on page 26.
Page 26. And let's see your appointment order.
The appointment order is on page 15, Lordship. Page 15, 1-5. This appointment letter has been issued on 25th June 2025, and the petitioner herein, namely Liltan Kima, who has bagged the third position.
Number 3.
Yes, Lordship. Serial number 3. Pu Liltan Kima.
This is after proper selection process.
After proper selection process, Lordship. On 25th, he got the promotion appointment letter, and on 27th, cancellation order was issued, Lordship. This is a departmental examination which was conducted on 29th and 30th of April 2025.
Okay, the impugn order was dated, page, your impugn order, cancellation.
Page 26, Lordship.
Okay, what was the reason given? Any notice, anything?
No,
Nothing.
there was no notice given except for the WhatsApp communication which we have given here, Lordship, on page 17, annexure 4A, which is in English translation. Sri David Sriadzela Irrigation, he is the superintendent, stating that they had made a mistake and entered the wrong mark in one subject. This was the only reason for the cancellation. But however, even though they stated that they have entered the wrong mark in one subject, there were 4 subjects which were redone, Lordship. The latest marks obtained is on page 29, serial number 5. Page 29, serial number 5. His roll number was 61, Lordship.
61.
So this was the marks obtained. And after asking through RTI on page 30, the petitioner had asked what marks he had secured in the prior to the to the marks they have made. So on this page 30, Lordship, this translation is on page 31. These are the marks he had obtained. So out of these subjects, they have written 4 marks, even though they had stated that they have entered only one wrong marks in one subject, Lordship.
They have changed in 4 subjects.
Yes, Lordship.
And are you the only one, or how many petitioners are here? How many petitioners?
I'm the only one, Lordship.
For the others, it was not corrected. For
For the others also,
1,
it
3,
was
and 4.
corrected. On page 27, Lordship, even though he has bagged the third position, he was kept in the waiting list, panel list, Lordship.
Okay. Third Learned Counsel for the petitioner, such and such. Stop. This petition under Article 226 of the Constitution of India has been filed by the petitioner, impugning the praying for setting aside of the cancellation order of his appointment or promotion.
Appointment,
Of
Lordship.
his appointment by order number A.12035/01/2021. You just see from the cost title, okay? Dated 27/6/2025. Stop. Para. The case of the petitioner is that the petitioner had appeared for a selection process for appointment to the post of sectional assistant level 4. Stop. On the basis of the results of the examination and on the recommendation of the DPC, the petitioner was appointed via order dated 25th June 2025. So you give the order number also. Via order number A.12035/such and such, dated 25th June 2025. This is annexure 3, okay? Dated 25 June 2025. Stop. However, by the impugned order dated 27 June 2025, the appointment of the petitioner along with another 3 sectional assistants was cancelled without giving any reasons and without giving an opportunity of being heard to the petitioner. Stop. Issue notice to the respondents number 1 and 2.
1 and 2,
Okay. As the learned government advocate, Ms. Such and Such has accepted notice on behalf of the respondents. No formal notice is called for. The requisite copies of the writ petition be served on the learned government advocate by the learned counsel for the petitioner during the course of the day.
Already served, Lordship.
Already served.
Yes,
Okay.
Lordship.
No, learned, in that case, you say learned counsel for the petitioner has already served the extra copies of the writ petition on the learned government advocate. So, the notice is made returnable within 4 weeks, at least after 4 weeks.
Obliged, Lordship.
For admission, item 4.
Contempt, yes.
My Lord, as per the last court's order 21/7/2025, at para 8, my Lord. You see, can you see para 8?
Para 8. Payment is likely to be completed within a period of 6 weeks.
My Lord,
Completed.
my Lord, I may be granted another 4 weeks' time for compliance with, because only 4 weeks is not enough for completing the proceeding.
Last time it was 6 weeks, now it's 4 weeks.
The judgment
Because
order was
we-
passed on way back on 2018.
However, my Lord, the verification
But
report
it-
had already been done in recently only, my Lord. We are only given only 4 weeks'
But
time.
is it being processed?
Yes,
Is it being processed for payment?
yes, my Lord.
And what about the updated status? You file in the form of an affidavit, your
Lord.
status. Have you filed?
Not yet filed, my
No,
Lord. We are only given 4 weeks' time only.
6 weeks.
No,
we
last time you were given 6
Today,
weeks. You were given 6 weeks.
my Lord, I may be given another 4 weeks' time for doing necessary action for the same.
Learned counsel for the petitioner, Mr. Victor L. Ralte is present. Stop. By the order of this court dated 21/7/2025, the respondents, you are respondent?
I'm for respondent number 2, 6, 9, and 12.
The respondents number 2, 6, 9, and 12, represented by MS Zarem Sangpui, had been given 6 weeks' time to place the updated status regarding the payment, regarding the subject of payment to the petitioners. Stop. Today, when the matter is called, the learned counsel for the respondent 2, 6, 9, and 12 has asked for a further time of 4 weeks to file the updated status report. Stop. As this is a matter of the court's order was 2019, na?
18, madam.
As this is a matter of compliance of this court's order of 3/9/2018, the respondent number 2, 6, 9, and 12 shall file the updated status regarding the payment to the petitioners in the form of affidavit before this court within a period of 4 weeks from today, without fail.
Yes, my Lord.
Okay. List of the 4 weeks.
Obliged.
Date may be fixed, madam.
Okay.
4 weeks will
So-
be due after vacation.
Yeah, that'll be after vacation.
7th of October, my lord.
7th or 8th? 8th.
We usually have division bench meeting
Oh
on
yes, division
Wednesday.
bench. In that case, 7th is not a holiday. 7th appears to be, okay then. 7th,
Deeply obliged.
7th October. And who are appearing for the other respondents? You are, okay, learned counsel such and such appears for
I'm for respondent number 14.
14.
This is not from Moya.
Okay, 14 and Mr. Such and such appears for respondent number 5. Yes.
Item 5.
Here also, my
Here
lord.
also.
Not of similar nature, my lord. Same award.
Here also payment.
Same award, yes, my lord.
Okay, here so same order fixed on 7th October for filing their status report now. And the respondents are
Respondent
represented
number
by 9. Mr. Such and such appears for respondent number 9. And here you are respondent in this petition?
I am respondent number 1, 2, and 7.
1, 2 and 7.
Oblige.
Item 13.
Your Lordship, this is a criminal review petition. Record may be called for, my Lord.
Record is required.
Maybe, my Lord. And another thing, Your Lordship. If I may kindly be allowed to file a short affidavit, my Lord, incorporating the departmental proceedings which was carried out in connection with the petitioner, my Lord. If that may be allowed also, my Lord.
No, but what has the departmental proceeding got to do
Proceedings
with the criminal case?
Actually, my Lord, it was alleged misappropriation of money from the MRB. He was earlier the ex-employee, terminated employee of MRB,
But-
Mizoram Rural Bank, Lordship. And then arising out of that issue, he was terminated as a result of departmental inquiry, my Lord.
But Lordship,
And
they are
as-
acquitted in the criminal trial.
And there is a parallel proceeding in the criminal trial, my Lord. And in that case, he was acquitted, my Lord. And as a result of that, my Lord, he now before
Then
Lord-
what are you challenging in this
Lordship, in this
petition?
matter, we are challenging the order specifically that some money was seized in connection with to the trial during the course of
Is,
investigation. So right now, in this judgment and order that is on page number
Oh, acha, acha. Then in that case, trial court records will be required. Yes. Heard learned counsel, MS such and such for the petitioner. Stop. Also heard Mr.
Caesar
and
also.
such for, you are for
MRB, Lordship,
the respondent number 2,
my Lord.
the Mizoram Rural Bank. And who represents the government?
Mrs. Linda is
Mrs.
appearing,
Linda, I
but
think.
maybe she's on legs.
Okay, okay.
She's on leg, my Lord,
Okay.
in court number
As the instant revision petition has been preferred against the judgment and order dated 29/2024 passed by the learned JMFC Champai Judicial District Champai in criminal trial 83 of 2019, the registry is directed to call for the trial court records from the court of the learned JMFC, isn't it?
Yes.
Yes, Your
JMFC Champai Judicial District Champai. Stop. And thereafter list the matter after 3 weeks.
Yes, Your Lord. In the meantime, if I may be allowed, my
After-
Lord, a short affidavit.
3 weeks. Sub-learned counsel for the respondent number 2 has also prayed for some time to file an additional affidavit or
Actually, yes, affidavit, yes.
file an affidavit bringing on record
Certain departmental,
the departmental proceedings
my Lord.
against the petitioner. Stop. The prayer is also allowed. The respondents shall file the same before the next date. Yes.
Deeply obliged.
Deeply obliged.
List after 3 weeks. Yes.
Item 14.
My Lord, can the matter be passed over for the time if the council is on legs in general?
Okay, this is that Delhi
Yes.
Delhi
And
council.
Miss Linda is also on legs in another matter.
Call after some time then. I think 14,
Item
15.
16.
Yeah.
My lord, I was
Yes.
instructed to pray another five months time.
5 months.
Yes, my lord. If I may produce my instruction letter.
5 months for what? Payment of rental compensation.
Yes, madam.
Anyway, petitioner is also not there.
None appear.
None appears for the petitioner when the matter is called. Stop. Learned counsel MS Zaram Sangpui is appearing for the respondents. Appearing for the respondents number
Number 2, 4, 8, and 11.
2, 4, 8, and 11 has prayed for 6 or 5 months.
5 months.
That is too much. Prayed for
6 months.
is prayed for 6 months to take necessary steps related to the court order dated 2/7/25 as the matter involves following governmental procedures which requires certain time. It is also stated on the basis of instructions received by her by letter dated 29/7/2025 from the Office of the Defence Estates Officer, Guwahati Circle, Guwahati, that the competent authority for making decisions related to payment of rental compensation to the petitioners is respondent number 11. Is that right? Is respondent number 11. Stop. Accordingly, the Learned Council has prayed for 6 months' time to comply with the direction of the court. Stop. This court is of the view that court order was dated 2/7/25.
2/7/2025.
This court is of the view that this contempt petition is related to non-compliance of the order of this court dated 2/7/2025. Where is the order? This court's order?
We are given 6 months time. 6.
In that you were
No, no,
given.
no.
The main petition is
We are given 4 weeks time.
here they have 2/7/25, nah. But here this is again 19/3/15. The petitioners have come for non-compliance of which order? Order dated?
Order, long time back, my lord. Order.
Order is of 2015. This is 10 years now. WPC 67 of
Yes.
2013, isn't it?
Yes, my lord.
Order in WPC 67 of 2013. Order dated 19/3/2015.
Yes, that one.
Yes. Yes, what did I say? As this is a matter pertaining to non-compliance of the order dated 19/3/2015 passed by this court in WPC number 67 of 2013, the respondents number 2, 4, 8 and 11. Is that right? 2, 4, 8 and 11?
I am representing for that one, my lord. The WPC was disposed of for spot verification, my lord. Spot verification of the land by constituting joint team. However, the joint team recently decided the matter. Then as per the court order, this order 2/7/2025, we are directed to make a payment only.
The initial order 19/3 was for spot verification.
Yes, yes, my lord.
Okay. And the latest order 2/7/25, that is passed in the contempt.
Yes,
Okay. 2, 4, 8 and 11. 2, 4, 8 and 11. Are given another 3 months. You take 3 months.
yes, my lord.
Another 3 months' time to make the payment as directed by this court in the present petition by order dated 2/7/2025. Stop.
Obliged.
Item 17.
Okay, the letter dated 29/7/2025 is kept on record and marked as X.
My lord, I'm here on behalf of Miss Mary L. Kiangte, and I have received instructions that some of the documents required for filing of the so-called reply is still awaited from the respondent. So if further 3 weeks' time may be granted.
This is for respondents you are mentioning for?
Respondent number 1, 3, 4, 7 to 11.
3, 4, 7.
In fact, my lord, in this case, respondent number 1 to 6 were the previous incumbents of the respective officials department concerned. And after transferring of the previous incumbents, these 7 to 11 were newly pleaded. And
Newly
they were already,
completed.
notice was already issued to them, and they were also represented by Miss Mary on the last occasion, and she had already sought time for filing so-called reply. But in this case, my lord, the matter pertains to regularization of SSA employees into the state government, my lord. This writ petition was disposed on 17/3/2023. And my lord, the operative portion is in page number 47, if I may take a lordship to page number
Yes,
47 of the contempt petition, my lord. Page number 47.
Page 47.
Running page number 47, para 23. This is judgment order dated 17/3/2023.
Yes,
Para 23, my lord. May I read?
paragraph 23.
Para 23, page number 47, para 23.
Yes.
And thus, upon due consideration of the case in its entirety, I find that the grievance expressed by the petitioner association to be legitimate and has merit. Accordingly, the state respondents are directed to consider regularizing the service of the members of the petitioners association against the existing vacant post of government teachers in the appropriate grade, keeping in mind the experience and training undergone by the members of the petitioner association and the object and mandate of the RTE Act, or in the alternative, to sanction new posts as SSA teachers by creating such cadre. It would also be open for the state government to frame a scheme providing for further terms and conditions on which such regularizations shall be done. Such an exercise should be initiated and completed within a period of 6 months from the date of receipt of certified copy of the order. My Lord, this was judgment order dated 17/3/2023, and most of the petitioner association, my Lord, members, who were 1,000 plus of them had rendered 20 years service in this capacity, my Lord. Now they're waiting for the regularization and implementation of this judgment order. But till date, we had filed this contempt petition way back on 2023, my Lord. But no steps have been taken by the respondents till date. So, my Lord, if they
Have they framed any scheme?
they have made, my Lord, and that one point, my Lord, that scheme, after that scheme was made, but that scheme was made for all CSS employees, not specifically for these people.
Not just for the SSA.
And in spite of the fact that they were having this judgment order, the state respondents had, in fact, regularized health worker under the Health and Family Welfare Department in the month of August 21st this year, without first considering the case of the present petitioners, my Lord. So, my Lord, the manner in which the respondents have acted upon in
Let
non-compliance
them
of this.
explain what steps they have been taking, because this order says to consider, are directed to consider regularizing the services.
And to initiate and complete the same, the last sentence, my Lord.
Such an exercise should be initiated and completed. No, that's why I'm saying, if there is substantial compliance by them,
No, my Lord, they have to regularize.
by initiating the scheme and, considering your cases, then they have to explain in the affidavit. And if there's...
Exactly, my Lord.
Yes.
So they have sought for time again and again. Whoever may be the incumbents of the secretary.
Oh, that means this 7
7
to
to
11 are new incumbents.
New incumbents.
New incumbents. And earlier incumbents, they have already filed.
No, my Lord, only one of them. So, my Lord,
Yes.
For number 5 and 2.
5 and 2. Okay.
even if they sought for
Yes.
time, my Lord, at
At
maximum
least
1 week, my Lord.
At least you should show what you have done
Yes, my
in
Lord.
compliance of this court's order. The court will have to see whether substantial compliance is there or not. Learned counsel for the petitioner, Mr. Victor L. Ralte, is present. Stop. Learned counsel for respondent number 2 and 5, Mr. Such and Such, is present and submits that the affidavit in opposition has already been filed for the respondents number 2 and 5. However, MS Such and Such, appearing on behalf of MS who? Mary L. Kiamte, appearing for the respondents number 1, 3, 4, 7 to 11, has made a prayer on behalf of the learned counsel to allow them another 3 weeks time to file the affidavit. Stop. Considering that the order of this court was passed, considering the fact that the order of this court was passed on 17/3/2023, this court is of the view that
My Lord, 1 point, if I
Yes.
may.
Yes.
The last court was on 2nd of July. They have already sought time on the day, 2nd of July. Now it was placed after 2 months, my Lord. Maximum 1 week, my Lord.
That, and in view of the fact that the order is of such and such, dated 17/3/2023, and also the fact that the respondents had already taken time on several occasions, the respondents shall file their affidavits within 2 weeks. You file within 2 weeks without fail. Stop. Yes. At least after 2 weeks.
Date may be fixed, my Lord.
Yes?
Date may be fixed.
You want a date?
Yes, my Lord. 18th.
Okay, 18th. Yes.
Deeply obliged.
Item 18.
It please, Your Lordship. My Lord, by filing this RFA, we have challenged the judgment in order dated 4/11/24 passed entitled suit number 58 of 2012. In this case, Your Lordship, some re-examination of the evidence may be required, in my humble opinion. So LCR may be called for in the meantime, or TCR.
Okay, TCR.
Your Lordship, I think the appeal is not yet admitted. And what I would like to point out is, my Lord, regarding the maintainability of the present appeal. Your Lordship, the present appeal has been filed by the son of the deceased party. That the deceased, the present appellant is the son of the defendant number 1 in the trial court. And after passing of the decree, the defendant number 1 unfortunately died. And thereafter, the present appeal has been filed by the son, arraying himself as the legal representative. So my point is that unless substitution is applied first, formal substitution is not there. And if we look at the provision of Order 22 Rule 4, so it appears that Order 22 Rule 4 CPC is also applicable in the appeal proceeding. So let him apply for substitution of his father first, and only thereafter the appeal could be taken up. And that is also subject to whether the right to sue survives. That will also be still the question to be considered. So my humble submission is that as it is, by simply filing of the present appeal by the so-called legal representative, whether he is the son of the deceased or not, then at least he should have filed the application for substitution. Otherwise, it cannot be taken up as it is, because, Your Lordship, the present appellant is not the party in the trial.
The suit.
Yes, in the suit, and we cannot consider as if this is the review. Review can be filed by any aggrieved party, but it's not like that. So since it is the continuation of the suit, appeal is the continuation of the suit, and due to the fact that this substitution under Order 22 Rule 4 has to be applied. So, my Lord, I have the citation also in that regard, saying that...
Otherwise, Your Lordship, may I make one small suggestion? We can take up the matter in the next court date on this issue of maintainability, as my learned friend has pressed.
I have no objection,
problem.
my Lord. Because
in the meantime, let the DCR be called for.
But unless
just
and
in
until
case.
it is
No,
admitted,
it
my Lord,
is
it
not
cannot
yet
be.
admitted.
Yes, it is not
So
yet admitted.
that's what I'm
Only-
suggesting. So that is what I'm suggesting.
Only
Your
if
Lordship.
it's
Yes.
admitted.
Let it be
then-
admitted. Let the TCR call and let my learned friend take up all this issue
No,
in the
it
next
cannot-
court date.
My Lord, unless and until it is admitted.
He is making preliminary objections regarding even the admission.
No issues, Your Lordship. Then we can take up the
So
issue.
we'll take it up on the next day.
Next week,
Are you filing any written objections?
regarding preliminary objection, yes, my Lord, if I may be given time.
Heard learned counsel, Mr. Surgeon Search for the appellant. Stop. Also heard learned counsel, Mr. Surgeon Search for the sole respondent.
So, my Lord, respondent number 1.
One.
For the,
The other two are
okay,
stated.
for the respondent number 1, who has prayed for some time to file a written objection regarding the maintainability of the present appeal. Stop. Prayer is allowed. How much time? 2 weeks?
2 weeks, ma'am.
This is the matter after 2 weeks, on which date the issue of maintainability shall be kept open. Yes.
Highly obliged.
Deeply obliged, Your Lordship.
Item 19.
Who's appearing for the petitioner? None appears for the petitioner when the matter is called. As per office note dated 1/9/2025, the learned counsel for the petitioner is yet to file the reply affidavit as prayed for. Stop. Accordingly, list the matter after 2 weeks. The learned counsel for the petitioner shall also file the reply affidavit, if so advised, before the next date. Stop. Learned counsel, MS such and such, appears for respondent
Here on
number.
behalf of Miss Mary, my lord,
Okay.
for respondent number 1.
Appears for learned counsel, MS Mary Kengti, who is for respondent number 1. After 2 weeks.
Item 20 for orders.
My lord, if this matter may be pass over for the time being.
The bail application,
Yes, my lord.
petitioner, you're for the
additional
petitioner,
the additional PP is on lags.
and petitioner, you're the petitioner.
Yes, my lord. My lord, if it may be taken up on Thursday.
Thursday?
towards the- Yes, my lord, I've taken the consent.
Thursday.
Obliged.
Item 21.
Condonation.
Yes, Your Worship, there's a delay of 1,163 days. But if Your Lordship will allow me, I'll just take Your Lordship to the annexure 1, page 10. This annexure 1, page 10 is the order dated 7th of December 2021.
2021. Yes.
This is the date on which the trial court had held the hearing in the absence of the present applicant, who was defendant number 4. And if Your Lordship will see, after the hearing was conducted at page 15,
Yes.
judgment order is reserved for 24th of January 2022, top of the page. Then if Your Lordship will see the next order, 24th of January 2022. Court is adjourned as trial judge is on leave, fixed 18th of February 2020 for jail. No signature of the trial judge. Again, 18th of February 2022, court is adjourned as the trial judge is on official duty. Again, fixed
Again,
25,
25
no one has signed the order sheet. And then, if Your Lordship will see, at page 17, annexure 4,
25-3.
24th March 2022, the judgment was pronounced in the absence of the defendant number 4, who is the applicant.
4 is absent without cause.
So, as per the CPC, notice has to be given to the parties regarding the pronunciation of the judgment. In this case,
Okay.
if Your Lordship will
So
see
you
annexure 2,
didn't know.
we didn't know at all. So, subsequently, we came to know about the judgment only when we got at page 18, annexure 5. English translation is at page 19. Subsequently, we received a order from the Revenue Department that the land has to be, the disputed suit land has to be redemarcated in pursuance of the judgment of the orders of the court. This is the only time when they came to know about the disposal of the suit.
Learned counsel for the applicant, Mr. A.R. Malhotra. Stop. This application under Section 5 of the Limitation Act has been filed, praying for condonation of a delay of 1,163 days in filing the connected RFA against the judgment and order dated 25/3/2022, passed by the learned civil judge,
Senior civil
senior civil judge, Serchip District, entitled suit number 1 of 2016. Stop. Para. Issue notice returnable within 4 weeks. The learned counsel for the petitioner / applicant shall take steps for service on the respondents number 1, 2, 3. But 1 and 2 are
2, 3
government
and 4 the
respondents.
state.
Yes.
We have already served notice upon them.
Okay.
2, 3 and 4.
Who's accepted notice? Who's appearing? Government counsels, learned government advocate, Ms. Such and such, has accepted notice on behalf of the respondents, for all the respondents.
2, 3 and 4.
Yes. Respondents 2, 3 and 4. Hence no formal notice is called for. Stop. In respect of respondent number 1, the learned counsel for the appellant / applicant shall take steps by registered post with AD as well as usual process within 3 working days from today. Least after 4 weeks.
I move that.
Item 14 for admission.
Easily, Bishop.
Yes. PP is here.
If I may, with your Ladyship's permission,
Yes.
argue the matter.
Yes. This is that matter 160.
Where notices under
160
160,
CRPC.
that is corresponding to 179 were issued to us.
Yes, yes. Yes, learned PP. Just give me, you have filed under BNSS or CRPC? BNSS,
Yes, 179.
179.
That is corresponding to 160,
Corresponding to 160, yes.
CRPC.
Yes.
Your Lordship,
What do you say?
In this case, I think wrong provision of law has been mentioned.
Yes, wrong
Yes.
provision because under 160 earlier,
160.
erstwhile 160 also, only those who are living within the,
Yes, it's only for the witness.
yes, only for the witness plus only those living within the jurisdiction of the
Yes.
police station.
It should be under 35 subsection 3.
Earlier 41, earlier
Yes,
41
yes,
CRPC, yes.
So wrong provisions of law have been mentioned.
So because this is for witnesses only, 160 is only for witnesses.
Yes,
It can,
it's
if
for
you want to
witnesses.
call me under a 41 notice, 41A notice. I'll be there before you.
We
under
will
40.
dispose it of them and then we will say that it will not come in the way of issuing another process, yes, if so advised. Yes, we will dispose it of them.
But appropriate provisions should be invoked. I cannot be called under, I cannot be witness in my own case. That is what the situation
No,
has
we
come.
will quash it.
Right,
And
right.
it's up to them. They can take fresh steps under different provisions. That's up to them. Yes. The present writ petition. No. I've heard learned counsel for the petitioner, Mr. Such and such.
Mohammed Faris.
Yes. And also learned PP, Miss Linda. Number 1. Stop. This present writ petition, the present writ petition is being preferred under Article 226 of the Constitution of India, praying for a direction to quash the undated notice issued under Section 179 BNSS in complaint case number 3/2023, registered by the Anti-Corruption Bureau, Aizawl, Mizoram, under Section 11/13 Clause 2, read with 13(1) Clause A, small a, and under Section 120B Section 11(13) read with 13A of what? PC Act?
PC Act.
Of PC Act and Section 120B/406/409/420 IPC. Stop. Para. The case of the learned counsel for the petitioner is that the petitioner had been served with the undated summon under 179 of the BNSS by the Anti-Corruption Bureau, Aizawl, Mizoram, in connection with the criminal case number 3/2023. Stop. It is stated that the petitioner is a resident of Delhi and therefore the issuance of such a summon is patently illegal and without jurisdiction and in violation of the statutory provisions as provided in Section 179 BNSS, which clearly provides that the police officer will require the attendance of any person within the limits of his own or any adjoining station who appears to be acquainted with the facts and circumstances of the case. Stop. Para. The petitioner's case is that he is a permanent resident of Delhi and does not reside within the jurisdictional limits of the Aizawl police station or any adjoining police station in Mizoram. Stop. Para. The another submission of the petitioner is that he is aged more than 65 years, and in view of his age and place of residence, he falls squarely within the category of persons protected under Section 179, Clause 1 BNSS. Stop. It is the submission of the petitioner that the issuance of such a summon violates and infringes his fundamental right under Article 21 of the Constitution. And this summon clearly reflects a clear abuse of police powers and mechanical and arbitrary exercise of authority. Stop. Para. Learned Counsel has relied on, you have given one judgment, no? Has relied on the case of
Directorate
of Enforcement and others versus State of West Bengal and others, reported in 2021 SCC online DEL 5603, comma, wherein your para,
I'll share that.
wherein the High Court of Delhi No.
24 onwards, Your Leadership.
Delhi,
It's the 24, 25,
the
26.
High Court of Delhi had held that
If specifically 27, if we may read. By mere reading of the provision, it becomes apparent that the power of the police officer to require attendance of a witness
had held that, comma, and open inverted commas, it becomes apparent that power of the police officer to require attendance of a witness is circumscribed by the words within the limits of his own or any adjoining station. Stop. It is to be noted that if the said power was in the nature of pan-India power, as has been sought to be argued by the respondents, there was no reason for the legislature to use the terminology quoted above. Stop. To the contrary, comma, if the same was the intention of the legislature, comma, the legislature would have clearly stated so and bestowed unlimited jurisdiction on the police officer by using terminology in the nature of anywhere in the country or even anywhere within the state. Stop. The clear departure of the legislature and the use of the terms within the limits of his own or any adjoining station points towards a legislative intention to limit the jurisdiction in this regard. Stop. The court subsequently held that if the respondents lacked the jurisdiction to issue the impugned notices, comma, the entire case of the respondents fail. Stop. Para. In this regard, therefore, in view of the above submissions, therefore, the General Counsel for the petitioner prays that the impugned undated notice under Section 179 of the BNSS against the petitioner may be quashed and set aside. Para. Learned Public Prosecutor Ms. Linda such and such has appeared for the state respondents and has fairly submitted that the notice under 179 of section 179 of the BNSS has been issued wrongly and under the wrong provisions of law, as the petitioner is not a witness, isn't it? As the petitioner is not a witness, but he is an accused person in the present case. Stop. Para. From a plain reading of section 179 BNSS, it is evident that for the purpose of investigation, a police officer can require the attendance of a person situated within the limits of his own police station or that of the adjoining police station, and not someone who is situated beyond the said territorial limits. Stop. This court is satisfied that the petitioner is a resident of Delhi and does not reside within the jurisdiction of the Aizawl police station or the jurisdiction of the respondent number 2, isn't it? Within the jurisdiction of the respondent number 2 and 3. Herein, stop. In view of the above facts and circumstances, the petitioners being residents of Delhi and also being a person above the age of 65, you said?
Yes, very much.
Above the age of 65, the impugned notice under 179 BNSS is quashed and set aside. Stop. However, this shall not come in the way of the investigating agency to take up any other proceeding under other provisions of law. Stop, if so required. Stop. Nor shall
that is outrightly giving liberty
no,
to
no, you just listen to me. Nor shall quashing of the impugned summon have any reflection on the merits of the case. Okay.
That is a specific direction. That's a specific direction to initiate proceeding against us leadership. No, that may be amended in let the investigating agency do whatever its call is, but that would be read somewhere, and that can be read rather.
Okay, then question set aside. No, they are at liberty. They can do anything.
They may be at liberty, but this particular statement may as well be read by anybody as a specific instruction to the investigating agency to initiate proceedings. Specific proceedings.
Okay. Don't say shall not come in the way. You delete that part and just say that this quashing of the impugned summon shall not have any reflection on the merit of the case.
Much.
Item 15.
Same order.
Yes, Your Lordship, same order.
Same order. Here, the petitioner is above 70 or something, no?
70 years.
70 years.
Hearing list, item 7.
Lordship, this item 7.
Is it a lengthy matter?
I mean, item 15 as well, leadership. If I
We had
suddenly
sought
got.
for hearing of that matter yesterday because of the fact that counsel, appearing on behalf of the respondent number 5, would not be available today. So, the day of the matter, he had informed me earlier that he would not be available.
Respondent 5.
Respondent number 5. Let it remain in the list. Let it remain in the list.
Let it come next week because tomorrow is division bench day and then Thursday will be my last day here, so it gets a bit difficult.
All right, no problem.
Because if we have to reserve and all that. the learned counsel for the respondent number 5 has some difficulties today. So learned counsel for the petitioner is present. Learned counsel, learned senior counsel such and such is present. So please the matter next week.
Lordship, there's another hearing item.
Which one?
Item number 4. Item number 5.
Item number 5.
For which what councils are present?
RFA. You ready?
Yes, Your Lordship.
Okay. Let's hear them.
It's RFA number 11 of 2018.
Yes.
Lordship,
Oh, paper book is also there. Yes.
the judgment which is impugned here is at page 76.
76. Jabu, ini je.
It's a judgment and order passed by the learned senior civil judge 1 in civil suit number 7 of 2010.
Senior civil judge. Yes.
I'll just read the first two paragraphs, Your Lordship, so that the matter may be clear to Your Lordship.
11.
The suit filed on 12/4/2010 for claiming of compensation amounting to rupees 10,53,358 and other consequential relief. The facts leading to the instant suit is that the plaintiff is having a plot of land at Procedural and is covered by LSC number G11 of 1992, which was purchased by the plaintiff from Lalbiak Sang, a miller, in the year 2007 for a consideration of rupees 2 lakhs. The plaintiff maintained the land by planting teaks of about 148 in numbers, and the defendant encroached the land of the plaintiff by cutting down those teak trees without prior permission of the plaintiff. The defendant contested the suit that there was no such teak trees within the land, but have any valid or proper passes. The suit is filed in the year 2010, and at the relevant time, the subordinate district council court was in function under the Administration of Justice Rules 1953, and subsequently Mizoram Civil Courts Act 2005, and therefore, according to the new act, the suit came before me for trial and disposal. Since the suit was endorsed to me by the competent authority and it was placed before me for trial. Defendants contested the suit by filing written statement. However, defendant number 1 did not adduce any evidence. Accordingly, the court framed the following issues on 26/10/2010. The issues are: 1, whether the suit is maintainable in its present form and style. 2, whether the suit land is looked after by the plaintiff before the defendant number 1 maintained. 3, whether the valuation of the suit assert by the plaintiff is reasonable as per the review rate. 4, whether the plaintiff is entitled to relief claim, if so, to what extent, and who is liable. On 15/11/2010, this court heard both the parties on the point of maintainability of the suit, and the suit is maintained on the same date, which is not appealed by the defendants, and hence issue number 1 is already decided in favor of the plaintiff. Regarding issues number 2 and 3, the plaintiff produced and examined 6 witnesses, including himself. Here, the defendant number 1 is Srilal Engmoya Zembo. Here in this statement, it has been stated that
the defendant number 1 did not adduce any evidence. This is an incorrect statement. The defendant number 1 had adduced evidence. His evidence is on record. And Your Lordship, the evidence, apart from the evidence, if I come to the findings, what is stated here is that regarding issue number 2 and 3, the plaintiff produced and examined 6 witnesses. But nothing has been decided, in the findings and reasons at para 14 at page 86, running page 11, internal page 11, running page 86.
Yes.
This is the finding and reasons.
Finding and reasons.
Yes. The plaintiff exhibited Certificate of Agricultural Land Settlement Certificate number G11 of 1992 and other documents without any objections from the defendants, which automatically proves that the plaintiff is the rightful owner of the sued property, and that despite the plaintiff and his witness stated and deposed that 148 numbers of teak trees valued at rupees 5,53,358 and 40 paisa only. In the meantime, D.W. Zalim Tsungi, who is the wife of defendant number 1, deposed during cross-examination that there was no pass in my name or defendant's name issued by the Revenue Department authority. Her evidence clearly shows that the defendant number 1 actually occupied the disputed land, and it is not the nature of a bona fide citizen to occupy the land which is not of his or her belongings. Therefore, issue number 2 and 3 are decided partly in favor of the plaintiff. Here, issue number 2 and 3, those are, the issues are whether the sued land is looked after by the plaintiff before defendants, number 1, maintained. 3, whether the valuation of the suit asserted by the plaintiff is reasonable as per the review rate. So here, in this manner, the learned trial court has said that issues number 2 and 3 are decided partly in favor of the plaintiff. It is decided that the plaintiff is planting teak trees within the sued land before the defendant number 1 occupied the land. However, it cannot be decided and admitted that such numbers of 148 teak trees were destroyed by defendants number 1. It cannot be decided and admitted that such a number of 148 teak trees were destroyed by defendant number 1. Under such situation, the plaintiff cannot be given the relief claimed, but he is entitled to some reliefs from the defendants. Accordingly, issue number 4 is also decided in favor of the plaintiff to the extent that the plaintiff is entitled to compensation amounting to rupees 5,53,359 and 40 paise, plus rupees 15,000 only as court fees. Regarding the issue to the effect that who is liable for payment of the reliefs, even though defendant number 2 did not adduce evidence, defendant number 2 had adduced evidence. In fact, Your Lordship, there is no any admissible evidence to put burden to him. Therefore, defendant number 1 alone is liable. No, defendant number 2 is someone else. There is no any admissible evidence to put burden to him. Therefore, defendant number 1 alone is liable and responsible to satisfy the aforesaid reliefs to the plaintiff. Para 15. It is therefore ordered and decreed that the plaintiff is entitled to get relief as compensation to the tune of rupees 5,53,359 and 40 paise, plus 15,000 as court fees due to the illegal encroachment and trespasses of his land covered under Certificate of Agricultural Land number G11 of 1992, located at Tuirial area. and defendant number 1 is hereby directed to pay the said amount of money within 60 days from today. So the matter has been decided in that manner. Your Lordship, in this connection, I'd like to take Your Lordship to the
Who is defendant number 1 and who is 2? Why are they father and son, or?
defendant number 1 is the one who is said to have encroached upon the land of the plaintiff.
Yes, and 2?
Defendant number 2 is Lian Thang Puya, Maobo, Aizol.
Why is he also implicated?
There, no reason has been mentioned as to why he has been impleaded.
Your Lordship.
Because
Your Lordship.
the court also is saying that there is no admissible evidence against defendant 2.
As
Yes.
per the plaint, the defendant number 1 had occupied the land of the plaintiff on the instruction of the defendant number 2, who had claimed that he was the owner of the land.
Right. So, the evidence of both parties were recorded. Lordship will see from the paper book, examination in chief of witness number 1, 2, 3, 4, 5, 6, and examination in chief of defendants witness Zarem Sungi, and examination in chief of Sri H. Lal Moya on affidavit. H. Lal Moya is the defendant number 1.
Examination in chief of one for the plaintiff.
Depositions, Your Lordship.
Serial number 9 and 10 are the defendants.
Yes.
That's number 1 for defendant.
8 is also. 7
7
is
7, 8, 9, 10.
witness for the defendant. 8 is the defendant number 1 himself, and examination in chief of witness number 1 for defendant number 1, Albert Luanga, and examination in chief of witness number 2 for defendant number 1, Almond Kima. 4 witnesses have been produced.
Yes, 4 witnesses.
May I take Lordship to the examination in chief of the defendants?
Page 58.
At page 58, page 58 is the statement, examination in chief on affidavit of Srimati Zarem Sungi, defendant witness.
She is the wife
She
of
is the wife of the defendant number 1.
defendant 1.
May I read the Lordship?
Yes.
I am the legal wife of the defendant H. Lal Moya, and as such I am fully aware of the case and circumstances of the case in civil suit number 7 of 2010. And as such I am competent to assure this affidavit that the land in dispute was temporarily occupied by my husband for installation of water pumping set for distribution to the needy persons, and for this purpose some portion of grasses and shrubs were cleared. My husband has no intention for permanent occupation of this land. The land adjacent to the pump set is a barren land covered by grasses and shrubs, and no one is developing the said land at that time, and my husband, defendant, presumed in good faith to be a free land, and he had planned for 1 year cultivation and cleared the land adjacent to the pump set for engraving levels. 4. That I was also present and accompanied my husband when he engaged laborers for clearing the said land for 1 year cultivation. The said land was covered by grasses and shrubs only, and there is no any single mature teak tree to be seen on the land, and none of the labor felled such teak trees within the land. The allegation made by the plaintiff against my husband defendant for felling of such teak tree plant and signboard a baseless and fabricatory statement with an intention to illegally get money from my husband. 5. That I was also present when the man sent by the plaintiff reached the said land for verification. My husband made his apology to the man of the plaintiff, stating that he presumed in good faith the land to be free land, and if the said land is owned by the plaintiff, he begged for his grace for illegal occupation of his land, and he abandoned and removed himself from the said land from that day. My husband had no intention for possession of ownership of the said land, and soon after we came to know that the land was owned by the plaintiff. We discontinued to look after the land and withdrew ourselves and never visit again from that day. On careful perusal of the copy of LSC number G11 of 1992 at Annexure 1 of the plain, it appeared that the said land was purchased by the plaintiff from Lalbiak Sanga Miller in the year 2007, and mutation or transfer was done in the name of the plaintiff on 2/2/2007. And considering to the fact that the plaintiff had purchased the land in the year 2007 and planted different kinds of plants and trees since the year 2007 as per the averment of the plaintiff in the plaint and evidence, I stated that such sticks cannot be estimated to grow big and tall as assessed by the man of the plaintiff at Annexure 2. 7. The plaintiff has no any reason or sufficient cause to file the present suit against my husband defendant, and the cause of the plaintiff are based on surmise and conjecture with a greedy intention of getting money from my husband. I have verified the contents, and she was cross-examined. She was cross-examined, and in her cross-examination, page 61, as far as my knowledge, the land in dispute was temporarily occupied by my husband in the year around the end of 2006 or the beginning of 2007. It is a fact that there was no pass in my name or in the defendant's name issued by the Revenue Department or competent authority. It's also a fact that I have no question about the land in dispute was possessed by the plaintiff or anyone else at the time of installation of water pump or for the means of 1 year cultivation. For it is a fact that considering the plaintiff had purchased the land in the year 2007, and there may be a different kind of trees. But I do not accept this planted trees or teak trees were planted by the plaintiff. There was no other land occupied by the defendant for installation of water pump, and there was no dispute with other person by doing this. I do not know the exact area covered by water pump shed and clearing of the land for 1 year cultivation. And she is re-examined. It's a fact that since the land in dispute is riverine area, we have no knowledge that the land was owned by any person regarding to the statement made in para D. Para 2. Regarding the statement made in para 4 of my examination at the time of occupying the land in dispute, I do not see many teak trees except one which I presume to be still standing today. Presuming but not accepting the condition that if there had been a teak tree in the said land, it was not owned or planted by the plaintiff. I accept that if there had been any plant or trees in the land, it belongs to the owner if he had bought it. And the defendant number 1 himself was also examined. May I read this again, Your Lordship?
Yes, please read.
Lal Eng Moya, son of Lal Thang Liana, so and so, that I am the defendant number 1 in civil suit number filed by Sub-Sona, and as such I am fully aware of the facts and circumstances of the case, and I am competent to swear this affidavit. I presume in good faith that the land in dispute to be a free land, and I had constructed pump set for installation of a small water pumping set for distribution of water to the needy persons. I had also cleared some portion of grasses and shrubs within the said land for this purpose. That the land adjacent to the pump set is a barren land, covered by grasses and shrubs, and no one developed the said land at that time, and also presumed in good faith the adjacent land to be a free land, and accordingly I have a plan for 1 year cultivation, and for this purpose I had cleared the land adjacent to the pump set by engaging laborers. That when the man of the plaintiff came and informed me that the land I had cleared for 1 year cultivation belonged to the plaintiff, I informed them that I presumed the land to be a free land and cleared grasses and shrubs for 1 year cultivation, and I expressed my apology and promised them that I would stop interference within the said land. Thereafter, I stopped and abandoned to look after the said land and vacate the land immediately. I neither told the plaintiff's man that I maintained the land at the instance of defendant number 2, nor with the permission of the Forest Department. When I cleared the land in dispute by engaging laborers, not a single mature teak tree was available to be seen within the land maintained by me for 1 year cultivation. The said land was covered by grasses and shrubs only, and the claims of the plaintiff against me for felling of such teak trees, plants and signboards are totally baseless and a fabricatory statement with an intention to illegally get money from me. I have no intention to have possession or ownership of the land, and I had merely used the land to make 1 year cultivation, and whatever I have done inside the land has been done in good faith. That on careful perusal of the copy of LSC number G11 of 1992, at Annexure 1 of the plain, it appeared that the said land was purchased by the plaintiff from Lalbiak Sanga Miller in the year 2007, and mutation or transfer was done in the name of the plaintiff on 2/2007. Considering the fact that the plaintiff had purchased the land in the year 2007 and planted different kinds of plants and trees since the year 2007 as per averment of the plaintiff in the plains and evidence, I stated that such teaks cannot be estimated to grow big and tall as assessed by the man of the plaintiff at Annexure 2. The plaintiff started planting teak trees and plants after he purchased the land that it was alleged by the plaintiff that I had cut down those teak trees planted by the plaintiff in the year 2007, and there was no averment in the plains that the previous owner, Lalbiak Sanga Miller, had planted teak trees and plants before the plaintiff purchased the land. There is no chance of teak trees and plants growing up and get maturity stage by 1 year. This clearly revealed that the claims of the plaintiff against me are totally baseless and is a fabricated story made by the plaintiff to earn illegally such compensation from me, and the suit is liable to be dismissed with exemplary cause even on this ground alone. That the measurement of teak trees alleged to have been cut down by me as annexed by the plaintiff in Annexure 2 of the plain have no credit worthiness. According to the averment made at the plains by the plaintiff, it appears that the land was purchased by the plaintiff in the year 2007, and he started planting teak trees and plants by the same year, and I was alleged to have cut down those teak trees in the year 2007. And such being the case of the plaintiff against me, which give rise to most impossibility and improbability of fast rate of growth of teak trees. Hence, the existence of measurement of teak trees made at Annexure 2 have no basis, and it has no credit and trustworthiness, which is liable to be discarded. Balance of convenience into the case is in my favor that there was no single teak tree to be destroyed inside the land developed by me for 1 year cultivation, and there is no such mature teak trees, and I have not felled down teak trees inside the said land, and as such I have no liability against the plaintiff, and the suit is liable to be dismissed with exemplary cause. Plaintiff have no sufficient cause of action and locus standi to file the present suit against me, and the cause of the plaintiff are based on surmise and conjecture. 10. That the claims of the plaintiff for rupees 10,53,354 against me before the Honorable Court cannot be maintained, considering the pecuniary jurisdiction of this Honorable Court. This Honorable Court being the Court of Civil Judge, having pecuniary jurisdiction of rupees 5 lakhs. These are all something else. And he was also cross-examined, Lordship, at page 66, cross-examination of defendant Naleng Moya. As far as I know, my knowledge is it was in the early part of the 2007. It's also a fact that there was no pass in my name or defendant since the land in dispute was situated in the river bank of Turiel. As far as my knowledge, the land in dispute was purchased by the plaintiff in the year 2007 and mutated the same in the name of the plaintiff on 2/2/2007. I did not know whether the plaintiff had planted teak trees in the land in dispute, and there is any single teak tree in the land when I occupied the land. I did not know whether the land in dispute was covered by the plaintiff's LSC or not. So those are the evidence adduced by the defendant number 1 and defendant number 1's witness. And there are 2 other witnesses of the defendant number 1. Nalruat Luanga at page 68. It's a short evidence.
Yes.
Let me read again.
Page 68.
Page 68.
Yes.
I'm a casual laborer by profession, and I earn my livelihood by working as a laborer in various fields. That I knew the defendant number 1, Naleng Moya, since long time back, and as I'm a manual laborer by profession, defendant number 1 used to employ me as a manual laborer as and when required. I do not know the exact date, but in the year 2008, I was employed by defendant number 1 for clearing the land at Turiel, which the defendant number 1 told us that land was barren, where no trees are available. 2 persons were employed along with me, and on reaching Turiel River, we found the land to be cleared was covered by shrub and grasses only. The defendant number 1 further told us that the land we are about to clear was vacant land, and he has no plan for he has a plan for 1 year cultivation. 5. That with other laborer engaged by defendant number 1, I cleared the land by cutting shrub and grasses. At the time of clearing the land, we found no teak trees or any other type of trees inside the land. There is no single teak tree to be felled on that land. I do not know how many days the plaintiff number 1 used for clearing the land for the purpose of 1 year cultivation, and I also do not know how many laborers were engaged by him for clearing the said land. I also came to know that way back in the year 2007, defendant number 1 had installed a water pump shed near the land we have cleared for cultivation. Defendant number 1 also told us that he has no intention of permanent use of the land, and since the land appeared to be vacant land where there is no any plantation of trees, he also supposed the land to be a vacant land and has cleared the said land for purpose of 1 year cultivation only. It was cross-examined. I am so and so. I am posting as a police since the last part of 2000. I know the defendant number 1 since I am renting his house. It's a fact that I do not know the disputed land was belonging to the defendant. It is a fact that I do not know the disputed land belongs to the defendant. I do not know the exact date. I and some other laborers were told by defendant number 1 to clear the disputed land. It's a fact that at the time of clearing the land, there were no trees but covered by shrubs and grasses. I do not know whether the one has installed a water pump set in the disputed land. It's a fact that D1 did not tell and does not told and show an LSC or PATA to us in order to show that he is the owner of the land. It's a fact that I know that the defendant said that the disputed land was vacant land. Paranai. It's a fact that there was a teak tree near to the road which was not very far from the place of our work, and we also use some for hanging the pipe. It is a fact that I am deposing. It is a fact that I am deposing the truth before the court today. So these are the statements, and in the examination in chief and cross-examination. And another witness of the defendant number 1, Lalmuan Kima, at page 72.
Page 72.
This is also very short. He is also a manual laborer.
He is also a laborer. Yes.
The two persons were employed along with me, and on reaching Turial, we found the land to be clear was covered by shrub and grasses only. Defendant number 1 further told us that the land we are about to clear was a vacant land, and he has a plan for 1 year cultivation. It's more or less a repetition of what was stated by the other defendant. And in his cross-examination at page 74, Para 2, as far as I remember, it was in the year about 2008, I helped the defendant for clearing the land for purpose of installing water pump. 3, it is a fact that at the time, I did not see any teak tree in the land except shrubs and grasses. It's a fact that the defendant number 1 had installed a water pump shed near the land we had cleared for cultivation. It's not a fact that I repose falsely. These are the statements of the witnesses for the defendants. And at page 74, Lordship, Para 3, what has been stated is important. It is a fact that
Page
74.
Oh.
It has been stated. It is a fact that at that time I did not see any teak tree in the land except shrub and grasses. So
both of them, they said the same thing, that there was no shrubs, there was no tree, but only
trees,
shrubs
no
and
trees.
grasses.
Yes. This has been reiterated, and even the other witnesses in the deposition have stated that. And in the cross-examination, accepting or admitting the statement of those witnesses of the defendants, even at the time of cross-examination, it has been suggested that there was no such teak trees, and they did not see any teak tree in the land except shrubs and grasses, to which he has said, yes, it is a fact. It is a fact that at the time I did not see any teak trees in the land except shrubs and grasses. And so far as the evidence of the plaintiff himself, may I take Lordship to page 35?
Page 35.
Page 35. Sapchona is the plaintiff.
So here, in this case, regarding title and ownership, there is no dispute.
There's no dispute.
Only the trees.
Yes,
which were
only
felled.
the trees, whether teak trees were
any
existing,
teak trees were
whether
there or
trees
not.
were felled. And if so, what will be the value of those teak trees? And whether the defendant, number 1, would be liable to compensate to give compensation or damages to the plaintiff. So here the plaintiff himself was examined in chief by way of this affidavit at page 35. He said, I stated that in the year 1992, Nalbiak Sangha Miller was issued certificate of land settlement certificate number G11 of 1992 under so-and-so District Agricultural Land Act 1963, covering a plot of land located at Tuirial. And the said land was purchased by me, and mutation was already done on 2000. It has to be 2007. In my name, and therefore owner of the said land. I stated that I have planted different kinds of plants and trees which are at their maturity stage. I stated that in the last period of the year 2007, defendant number 1 entered in the garden and constructed a Jum hut and destroyed different kinds of plants and trees belonging to me. Upon hearing the situation and circumstances, I sent his relatives, namely Thang Ruala of Bong Kon Sim Veng, Vanal Chuanga of Dorpui Veng Thar, Nal Dua of Tuikuan and Nal Nunmoy of Chan Mari on 20/1/2008 at the spot, and defendant number 1 is also present in the said Jum hut. At the time, Pipata number 147 of 1978 was also shown to him, and stated that he was directed to advise and advised by the defendant number 2. The defendant number 1 further stated that he was allowed by the Forest Department to maintain the land for a period of 1 year. Upon inquiry, the concerned DFO denies the affirmation of the defendant number 1. I state that some of his relatives to take measurement and numbers of plants and trees destroyed by defendant on 29/5/2008, asking for the false claim. It is not a fact that the plaintiff filed a suit on the basis of false and fabricated statement. So those are the statements. So far as the examination chief are concerned, they are all prepared, and they ask the the witnesses to come and put their signature, and that was submitted, and thereafter they were cross-examined. But since it was not of their own version, they have made such statements which are contradicting to what they were shown to have stated in the affidavit in the evidence. So my understanding of the case is that since the plaint, reading of the plaint, also did not disclose that the previous owner, Nalbiak Sangha himself, planted any teak trees in the garden before it was purchased by the plaintiff. There is no evidence to the fact that teak trees were in existence. In spite of the statements made and fabricated by those witnesses, it was clearly evidenced that those statements were prepared, and they were simply asked to put the their signatures. And neither the plaintiff nor the previous owner had adduced any evidence to show that the teak trees were planted and were existing at the time the defendant had entered in the said garden in the year 2007 or 2008. And the value or the rate shown at Annexure 2. Lordship, I have not shown Annexure 2.
Page 17.
17, yes. This has been the calculated rate of teak trees felled by Pulal Eng Moya, owner Sapsona Colony, Turial Lake Saping Sulkiaram. Number of teak trees, 148 numbers. So the manner in which this record has been prepared is very scientific. They all said that they have no knowledge about the forest laws and all that, but one of them said that we have prepared as instructed by the plaintiff.
Instructed by plaintiff.
Yes. So the local name is teak, and the botanical name Tectona drandis. It appears that the plaintiff is also a forest officer who had some training in forestry. Botanical name Tectona drandis, class A1, girth in inches. There are the girth in inches. They are all shown. Girth in feet, height in feet, value. So the total value has been shown at page 19 to be rupees 5,53,357.40. So when there was no teak lock inside the garden, when they said they had visited, there was no teak lock. Only what we saw is the stump of the teak tree, which was felled, but no teak locks were available. So,
and one of the PWs also said that they did not measure or
they did not measure
do anything.
And one of them said that he's making this assumption or assessment, the value or rate, on the basis of assumption. As per their training under the forest department. If the size of this is this much, the girth is this much, and then it must be the height of of this particular height. So it's all presumption. And this has been exhibited at Exhibit P2. There is no authentication whatsoever. No signature has been appended herein. And the manner in which this has been exhibited, it was simply exhibited Exhibit P2. Just because it was exhibited as Exhibit P2 does not mean that the contents are proof. And it is not even the first copy, and it is not authenticated copy. It is simply a piece of paper on which different datas were written with the total amount of rupees 5,53,357. So, Your Lordship, there is no authentication of Exhibit P2. It cannot be taken for the purpose of making the defendant number 1 liable for the said purpose. It was not proof. And PW number 5 at page 52 had said, all what I knew in this case are derived from the plaintiff. Though he had said so many things, but in his cross-examination, what he said was that all what I knew in this case are derived from the plaintiff. So he did not see any teak lock in the garden. That is what he said at page 53. The height of the teak trees made and assessed were without seeing the teak locks at page 53 also. That's what he said.
I do not
That
see
is the defendant, the plaintiff witness number 5.
inside the document.
And he also said at page 53 that Exhibit P2 was made as per the demand of the plaintiff,
Without seeing the tick
without
lock.
seeing the teak locks. And he did not see any teak lock in the garden. The height of the teak trees, that was as per his assessment, he made and assessed without seeing the teak locks. And all what I know in this case are derived from the plaintiff. That is what he said at page 52. And during the cross-examination, even the plaintiff witness number 3 had said at page 48, he could not say when he went to the garden of the plaintiff. It is quite doubtful as to whether they had actually gone to the garden or not. Apart from what they have seen, it is a matter of doubt as to whether they had really visited the site. Even the plaintiff did not go. They simply said that we have been sent by the plaintiff.
Plaintiff did not go.
And PW number 3 said he could not say when he went to the garden of the plaintiff at page 48, and he did not know the number of teak trees said to be false, as they did not count it. At page 49.
Did not count the number of trees.
On the other hand, the defendant number 1, who had adduced his evidence, and even the witness, his wife, Srimati Zarem Chungi, they said they had entered the garden without taking permission of the plaintiff. They had admitted that they had entered into the garden land. But they, all the witnesses of the defendant number 1 had clearly stated that there was no teak tree, it was all shrubs and grasses when they cleared the place for installation of water pump and for 1 year cultivation of the site adjoining the site for water pump. And that portion of land which they had cleared was also abandoned as and when they were informed that it all belonged to the plaintiff. So without any intention of encroaching upon the land of the plaintiff, they had entered into it. That means they did not have any guilty intention. And when they were informed that the sued land belonged to the plaintiff, they had abandoned it. And the purpose of installation of that water pump was also for purpose of distribution to those needy persons in the surrounding areas.
They thought it was no man's land.
Yes,
They said
yes.
that.
That's what they said.
And plaintiff himself is saying, I personally do not know who felled those teak trees inside my land.
And they did not say that there was no teak tree at all. But one of the witnesses said that there was one teak tree on which we had also hanged one of our materials. They identified the existence of one teak tree, which they had utilized for that purpose. But the manner in which they have been shown to have encroached upon and done such things, that was not proved. So in other words, the defendant number 1 does not dispute the title of ownership of the plaintiff over the sued land, and however, he disputes that the plaintiff ever had teak trees within the garden land, and that any felling of teak trees caused by him or his laborers. So a blanket denial is there. And the claim of the plaintiff was without any basis, and even Exhibit P2 cannot be relied upon, as it was not proved in accordance with the requirement of law. And at the same time, there was a contradiction in the judgment of the learned trial court also. If I take a lordship back to page 86.
The court said the defendant did not adduce any evidence, so that is also wrong.
That is wrong. So this judgment appears to be made without referring to the evidence, only on basis of conjectures or surmises. If I take a lordship back to the findings and reasons thereof,
Yes.
on the light of the evidence that has been read out. At para 14, the plaintiff exhibited certificate of agricultural land and other documents without any objection from the defendants, which automatically proves that the plaintiff is the rightful owner of the sued property, and that despite the plaintiff and his witness stated and deposed that 148 numbers of teak trees valued at rupees 5,53,358 and 40 paisa only. In the meantime, D.W. Zarem Chungi, who is the wife of defendant number 1, deposed during cross-examination that there was no pass in her name or defendant's name issued by Revenue Department. Her evidence clearly shows that defendant number 1 actually occupied disputed land, and it is not the nature of the bona fide citizen to occupy the land which is not his or her belongings. Therefore, issue number 2 and 3 are decided partly in favor of the plaintiff. It is decided that the plaintiff is planting teak trees. It is decided that the plaintiff planting teak trees within the sued land before defendant number 1 occupy the land. This is also without any evidence how the learned trial court had come to make such a decision. Plaintiff had never said that he had planted teak trees, and even the earlier owner, that is Nalbiak Sanga Miller, he did not say anything that he planted teak trees within his garden land. So how could the learned trial court make a decision that the plaintiff is planting teak trees within the sued land before the defendant number 1 occupied the land? However, it cannot be decided and admitted that such a number of 148 teak trees were destroyed by defendant number 1. Under such situation, the plaintiff cannot be given the relief claim, but he is entitled to some relief from the defendants. Accordingly, issue number 4 is decided in favor of the plaintiff to the extent that the plaintiff is entitled to compensation amounting to this amount shown as the compensation to be given to the plaintiff, that is 5,53,359 and 40 paise, is the calculation.
That is the calculation. Exhibit,
made
exhibit
at the
2.
end of the Exhibit 2. So Exhibit 2 not having been proved and authenticity never proved by the plaintiff during the course of the proceedings, this amount cannot be saddled as the liability of the defendant number 1. And in fact, it's a case of falsely accusing the defendant to have caused damage to the property of the plaintiff. There should have been a cross or counterclaim to be made by the defendant number 1, but no such counterclaim was made. So, in view of the false accusations and the allegations made against the defendant number 1, the plaintiff in fact is liable to be given the liability of paying at least some amount of compensation to the defendant. Lordship, before closing, may I just take Lordship to one of the judgments, that is 2013 to SEC, page 114. May I take Lordship to paras 15, 16 and 17.
Yes.
Paras 15, 16 and 17.
Regarding secondary evidence.
Yes, regarding secondary evidence. In para 15, in J. Yashoda versus K. Shobha Rani, that was decided in 2007, 5 SCC. After analyzing the language employed in section 63 and section 65A, two judge bench held as follows. Section 65, however, permits secondary evidence to be given of the existence, condition or contents of documents under circumstances mentioned. The conditions laid down in the said section must be fulfilled before secondary evidence can be admitted. Secondary evidence of the contents of a document cannot be admitted without non-production of the original being first accounted for in such a manner as to bring it within one or the other of the cases provided for in the section. Section 63, 65. It has been quoted. Section 65, however, permits secondary evidence to be given of the existence, condition or contents. Supposing that the Exhibit 2, P2 is secondary evidence, whether it is admissible as per law, though it is not authenticated, no signature, no date, such. Lordship, Section 63 of the Evidence Act, I'll just read out. Secondary evidence means and includes 1. Certified copies given under provisions hereinafter contained. Certified copies. It is not a certified copy.
It is not a certified.
And 2. Copies made from the original by mechanical process, which in themselves ensure the accuracy of a copy and copies compared with such copies. So it is not copies made from the original by mechanical processes. That is some sort of these photocopies. If photocopies are compared with the original, then that is also a secondary evidence. It can be taken as. 3. Copies made from or compared with the original. 4. Counterparts of documents as against the parties who did not execute them. 5. Oral accounts of the contents of the document given by some person who has himself seen it. So, from reading of the provision of Section 63 of the Evidence Act, this Exhibit P2 cannot be said to be even the secondary evidence. And 65 is lots of cases in which secondary evidence relating to documents may be given. So when we say that it is not even a secondary evidence, this 65 may not be required. But since it has been relied upon here, cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition or contents of a document in the following cases. A, when the original is shown to appear or appears to have to be in the possession or power of the person against whom the document is sought to be proved, of any person out of reach of or not subject to the process of the court, or of any person legally bound to produce it, and when after the notice mentioned in section 66, such person does not produce it. When the existence, condition or condition of the original have been proved to be admitted in writing by the person against whom it is proved by or his representative in interest. When the original has been destroyed or lost, these are instances of relying of the copy, on the secondary evidence. But we say that the document which is relied upon for the purpose of making a claim against the defendant number 1 is not even a secondary evidence. So here in M. Chandra versus M. Tangamuthu, it has been held as follows. It is true that a party who wishes to rely upon the contents of the document must adduce primary evidence of the contents, and only in the exceptional cases will secondary evidence be admissible. However, if the secondary evidence is admissible, it may be adduced in any form in which it may be available, whether by production of a copy, duplicate copy of a copy, by oral evidence of the contents, or in any other form. Secondary evidence must be authenticated by foundational evidence that the alleged copy is in fact a true copy of the original. It should be emphasized that exceptions to the rule requiring primary evidence are designed to provide relief in a case where a party is genuinely unable to produce the original through no fault of that party. So all such circumstances would not arise in the case at hand. So he simply prepared the assessment as per the instruction of the plaintiff, and that was simply put in the case record without any authentication, and that was also not given any particular date or authenticity for the purpose of authenticity. It is simply shown as Exhibit P2. This cannot be the basis for making a claim against the defendant number 1. So in view of all this, Lordship, the manner in which the learned trial court, that is the Court of Senior Civil Judge, had come to these findings is not proper, not acceptable, and it is not based on evidence, and is in fact against the law. So the defendant number 1 not having done anything against the plaintiff, nothing is proved against him. In that view of the matter, the appeal may be allowed, and the decree which has been passed by the learned trial court be set aside and quashed. That's
Okay.
it. I conclude with that.
Okay. We'll continue at 2.
Your Lordship, if I may interrupt.
Yes, yes.
Sorry.
Adjournment.
Actually, Your Lordship, I failed to appear on part 1, item number 19, because I was experiencing some digestive discomfort at that moment. I was the petitioner, and although the orders has already been set. Your Lordship, can you please, if the court insists, can you please reflect my presence?
Item
Item number 19.
19. Okay,
And
just
Your Lordship, one thing, as far as I am concerned, I believe that only the respondent number 1 appear, and respondent number 2, although the ID card has already been returned, but still they fail to represent.
Is it a contempt matter?
Yes, Your Lordship. And due to their non-appearance, I can't file my rejoinder also.
Okay. 2 weeks was given, I think.
Yes, Your Lordship.
On the next day, you raised the point again. Yes.
Yes, Your Lordship.
Otherwise, your name will be. Yes.
If I may, Your Lordship. Firstly, Your Lordship, I would like to bring your attention to the fact that the respondents were, the appellant was in occupation of the disputed the property of the plaintiff in the, as per the evidence of the DW1 and 2, they were in occupation of the said land in the beginning of the year 2007. So in that aspect, what I would like to bring to your Lordship's attention is that at page at page 68 of the paper book, examination in chief of the defendant witness number 1, which is also similar to page number 72 at para 3.
Page 60?
68. In chief of Sir Watuanga, defendant witness. Here, Your Lordship, both of them had, both of the defendant witnesses, 68 and 72, at para 3, they had, this one is at para 3, 68. I do not know the exact date, but in the year 2008, I was employed by defendant number 1 for clearing land at Tuirian, which the defendant number 1 told us that the land was barren when no trees were available. In this regard, Your Lordship, the defendant was already in occupation of the appellant was already in occupation of the land since beginning of 2007. Now, these witnesses were only employed in the year 2008. So it is acceptable that they are not aware of the presence of any teak trees because clearing of the land, as admitted by them at para 6 onwards, page 69. That I do not know how many days the plaintiff used for clearing the land for the purpose of 1 year cultivation, and I also do not know how many laborers were engaged by him for clearing the said land. At para 7, I also came to know that way back in the year 2007, the defendant number 1 had installed a water pump shed near the land we have cleared for cultivation. So this goes to show that the land had already been cleared in the year 2007 before these 2 witnesses came into the picture. So it is it is possible that they have no knowledge regarding the existence of any teak trees because clearing work had already been taken up in the year 2007 and they were only engaged in the year 2008. That is my first point, Your Lordship. And second is that regarding the existence of the teak trees, PW number 5, who is Lalbiak Sara Miller. He had stated in his cross-examination that he, along with the previous owner, had planted the teak trees, which is at page 42.
Where is that?
40. Page 43, Your Lordship. Paragraph 4, last line. It is not a fact that there are no teak trees when I sold my landed property to the plaintiff. So the land was purchased in the year 2007, in the beginning of the year 2007. And at this time, this witness, the previous landowner, had stated that he had planted, there were teak trees available at the time when he sold the land. So this clearly, and this evidence was not rebutted, and this evidence clearly shows that there were teak trees available at the time of sale, which is in the beginning of 2007, when the defendants, the appellant also purportedly occupied the land. And at para 6 of page 44, Your Lordship, the same witness, the previous owner, had stated it is a fact that the plaintiff did not mention that myself and the former owner of the land.
Where is that?
Page 44, para 6.
Yes.
It is a fact that the plaintiff did not mention that myself and the former owner of the land planted those trees inside the land. Lordship, this clearly shows that the trees had been planted, they were in existence at the time of purchase, and that the appellant had occupied the land around the same area. But when the land was surveyed by the other witnesses who had gone to confront the appellant, the trees had already been felled. And one other aspect is that
but the PWs stated that they never saw any trees.
Your Lordship, PW, the first one, he stated that he saw lots of trees.
The other PWs?
The other PW, in their examination in chief, they stated that they had seen the trees. They did not see the felling of the trees. They did not catch the defendant, the appellant, in the act of felling the trees, but the trees, as per their statement, had already been cut down. And what was raised by my learned friend was that, as per the person who had prepared the report, if I may bring your Lordship to page number 53. At para 8, when we went, we have seen teak trees which have been cut at the ground level. So even though he did not see the logs, he saw the
stumps.
He saw the stumps. So which.
However, I did not find any teak tree inside the garden.
But the stumps were there, which means that they were cut down. And another point which I may raise is that regarding the question of secondary evidence, which was brought up by my learned friend, learned senior counsel, Your Lordship, the secondary evidence as per section 63 of the Evidence Act is what would have been, as if I may read that section, Your Lordship. Section 63, subsection 5. He had oral accounts of the contents of a document given by some person who has himself seen it. So he had gone, the person who had prepared Exhibit P2, which is the evaluation of the trees, he had gone to the site and he had also witnessed the stumps of the trees which had been cut down. And he was the one who had prepared the estimate based on his technical knowledge in the field as he was working under the Forest Department.
But he said that he did not measure the trees.
He did not measure the logs.
He did not measure the logs.
But based on his observation from the assumption and observation from the stumps and that were left behind, he had made this estimate. And as already admitted, there is no denial that there is no denial regarding the ownership of the property.
That there is no denial. It's only the assessment, how it was made.
No, Your Lordship, I'm talking about the ownership of the property.
Ownership, there is no dispute.
There is no dispute, and there is no denial regarding the occupation of the property as well. But Your Lordship, if
they have said that they didn't know that it was someone's land.
Yes.
They thought it was no man's land.
Yes.
So as soon as they came to know that the plaintiff was the owner, they vacated this document.
That was after a year of occupation, Your Lordship. The appellant has stated that clearly in his examination that he had occupied the land from the beginning of 2008. And the plaintiff had sent his men only in the beginning, or sometime in the year 2000, occupied the land in the beginning of 2007. And the plaintiff had sent his associates in the beginning, in the year 2008. So he had one whole year of occupation of the land. And Your Lordship, the entire evidence need not be reiterated again at this stage, but
no, but how the trial court came to a decision finding that 148 teak trees were destroyed, and that this compensation amounting to such and such rupees. So on what basis?
Given that, Your Lordship, I concede and I submit that I am not
Yes.
sure as to how the trial court...
Okay, the fact that they occupied the land and all that, that is that
Not
may be
contested,
proved, that
yes.
has been proved. But about the felling of the trees, the numbers, and then the amount of compensation, there's nothing in the evidence. How the court came to a conclusion that, anyway.
Regarding the number of trees, Your Lordship, I do not have an answer to that aspect. But regarding the felling of trees, the plaintiff witnesses have clearly stated that one of the plaintiff witnesses stated that he saw the logs, and even though the other witness did not see the logs, he saw the stumps. And the defendant number one and his wife are interested parties who claim that there were no teak trees, and the other defendant witnesses were not there at the time of the initial occupation of the land, and only came after one session of clearing had been done in the year 2008. So based on preponderance of probabilities, Your Lordship, it can be...
Then the plaintiff will come to page 40, the cross of the plaintiff, para 13. It is a fact that I had abandoned the teak trees which have been fallen at my will. I had no any intention to collect those teak trees for the purpose of selling. Then how they did not see the teak trees? Because he said that he did not collect them, he just left them.
Yes. He did not collect them because they had already been felled by the, as per his statement, as by the defendant number.
And then he also said that he personally does not know who felled those teak trees inside my land.
Yes.
In his cross.
But surmising, Your Lordship, it can be only assumed that he purchased the land in the beginning of 2007. And the PW number 2, the previous owner, had stated that at the time of purchase, the trees were still planted in the land. So it is only the defendant number 1 who had occupied the property since the property was sold to the plaintiff. So that...
Can we go by surmises and conjectures when the plaintiff himself is saying he does not know who felled the teak trees?
But Your Lordship, in matters of civil nature, as you are probably aware, as you are most definitely aware.
No, of course, may not be beyond reasonable doubt, but still.
And Your Lordship, one other factor is that one of the defendant witnesses also saw one teak tree. One teak tree.
One teak tree, yes.
From there,
Standing.
another assumption can be drawn that if one teak tree is there, there is a possibility of other teak trees being there in the past as well.
Maybe, but...
And the people who wholeheartedly claimed that there were no teak trees were only the defendant himself and his wife. And none of his witnesses claimed that there were absolutely no teak trees at any point of time. So
it was only the two workers who said that when they went, there were no teak trees.
Yes, but that was
But
after
you are
a year.
saying that is in 2008.
Yes. And that is pretty much my submission, Your Lordship.
Yes, any reply or? I think you have covered everything.
Yes.
Okay. Item 5. No? Item 5. Heard learned senior counsel, Mr. C. Lalram Zuava, assisted by Mr. such and such. So also heard Mr.
Jonathan Winkler.
for respondent number 1, right? Respondent number 1. So hearing is concluded. Judgment reserved. Any more?